time is 1:47. The date is August 17, 2017. My name is Michael Abraham on behalf of Planning and Development Service Department. I'd like each of the committee members to introduce themselves starting on the right.
Andrew Loper, Imperial County Fire Department.
Ray Romero, Imperial County Pollution Control District.
Paul Deal, Ag Commissioner's Office. George Pettis, Environmental Health.
Thank you. We have one item on the agenda today. It's an informational item. It's assessment 16-0008. The applicant is United States Gypsum, and this is also a scoping meeting for supplemental EIR. Patricia, as well as the project planner, please read the project summary to the record.
Good afternoon, Commissioners. Just as Mr. Abraham stated, this project was submitted by U.S. Gypsum. It's the U.S. Gypsum Expansion Modernization Project that was submitted and approved in 2008 due to litigation, which we could explain in more detail later. The appellate courts decided that we needed to work on some mitigation measures. The county determined, because of the scope of the mitigation measures, that we would do a supplemental to the EIS, which was previously approved in 2008. And so we felt that a supplemental would be the appropriate secret document. We also have present Adam Cook County Attorney, and then Cheryl Tubbs with Wilburn Corporation is the county consultant that's be working with county staff on this project to complete the document. And she'll be going through a slideshow. I just want to let you know this project is located in the town side of Ocotillo because that's where the wells are at, but the U.S. Gypsum, of course, is in Foster City, so that's why you have various APNs and parcel sizes was not able to determine the pH. And so I'll turn it over to Cheryl for the slideshow.
Okay, Patricia's already hit on a couple of these slides, so if we could go to the one with the figure of the Ocotillo Coyote Well groundwater basin. So this is basically the area in question where U.S. Gypsum has 3 production wells in the community of Ocotillo, and where the potential impacts from increased groundwater pumping would occur with expansion of their quarry and plant operations. So, now if you will go back one slide, please. I'm sorry, yeah, that's it. Patricia already went over briefly why we are here today, why the county is preparing a supplemental EIR. And this is just to focus on the mitigation measures that were proposed in the 2008 EIS that were subject of a legal challenge, and the court decision was to go back and revise those mitigation measures. The judge felt that they did not significantly reduce the potential impacts to the regional groundwater aquifer or to individual wells. So that's been the focus of work that we've done since the court order was sent down to the county. The county hired Wilburn Corporation. We did do the final EIR in 2008, and we have been working with the county for the last year and looking at alternative mitigation measures that would be feasible and that would alleviate any potential impacts to individual wells in the Ocotillo Coyote Wells groundwater basin. It's important to note that the court also determined that all other aspects of the 2008 final EIR, which was certified by the county, were adequate, and so the project that was evaluated stands as approved by the county, with the exception of the mitigation measures related specifically to groundwater resources and water levels and water quality. Okay, next slide. Actually, 2 more, please. So we spent a lot of time with county staff, environmental health services, as well as planning, and we spoke to the 2 mutual water companies that have wells in the groundwater basin to try to determine what really would work in lieu of the mitigation measures in the prior EIR, which were to bring in bottled water, or to rehab the wells, or to put new pumps on them. those really weren't determined to be feasible in subsequent conversations with environmental health, because bringing in bottled water is just a short-term fix, and the county needed to have something that was long-term. So the first revised mitigation measure that we've come up with is the proposed expansion would allow USG to withdraw up to 767 acre-feet a year to meet their proposed expansion of wallboard manufacturing. Right now, they're allowed to withdraw 347 acre-feet a year, and the proposed project was for up to 767. So instead of fixing that at an annual limitation, we put a monthly limitation so that there can be more monitoring, and the county can determine through hiring of hydrogeologists on a regular basis, instead of just the annual basis that's being reported to the county right now. So the limitation will be 96 acre-feet in any month, rather than looking at an annual production limitation. The limitation now is on a monthly basis. If for some reason, USG, as we all know, all businesses are not necessarily steady month to month. There may be some months where their wallboard demand increases. There may be some months when it's substantially lower. And so any month where they expect to exceed 64 acre-feet in a calendar month, then they would have to start monitoring on a weekly basis. There are existing wells, individual wells, monitoring wells that the United States Geological Survey has and collects regular data on, as well as what USG reports to the county on an annual basis. So there is a fairly significant and extensive groundwater monitoring system in place. So that would be reduced to collecting samples or collecting the data on a weekly basis. The next slide, please. Revised mitigation measure 2 is to continue the monitoring program, which the county has posted again, and will be a part of the supplemental EIR that we're doing. That still stays in place. We did another evaluation. There was a hydrogeological firm called Todd Groundwater that worked under subcontract to Lilburn Corporation. They reevaluated the monitoring program. They reevaluated all the data that they've been compiling for the annual reports for USG to submit to the county. And they feel that that monitoring program is still sufficient with the thresholds that we just discussed in mitigation measure 1. So the groundwater levels that were projected in the 2008 EIR was a decrease just due to groundwater pumping that has historically happened, and to the hydrologic cycle of 1 foot over a 10-year period. And so that threshold that we had in the 2008 EIR of a decline of 0.18 feet in any year for 2 consecutive years would be when we kick in some other type of stipulations. Next slide, please. The second part of mitigation measure 2 focuses on water quality, and any water quality concentrations exceeding 95% of the upper confidence level for 2 consecutive years is when some of the stipulations would kick in. I can explain that upper level confidence level, and I will, because I asked Todd Groundwater to explain it, and I got a scientific explanation that didn't make any sense to me. So the upper confidence level for any contaminants or constituents that are in the groundwater, such as naturally occurring things, or nitrates or total dissolved solids, is the upper range of what they expect to see in water quality concentrations for a well. It's based on the number of sample and the ranges of previous concentrations. There are natural variations in water quality concentrations that occur throughout a period of time, such as a year. But if a sample is higher than the USL, it signifies a pointed increase. So in other words, we take the measurements that have occurred over a 2-year period and take the upper confidence level being 95% of that, And if any of the water quality measurements come back above that level, then we know there's some type of measurable significant increase in water quality constituents. Okay, if we have a significant impact based on these thresholds that I've just identified to water quality or to water levels in an individual well, then the county will be able to, by adoption of these new mitigation measures, require U.S. Gypsum to decrease their pumping back to their current baseline level, which is 347 acre-feet a year. That's what they're allowed to pump now. Next slide. Okay, document a reduction in production rate of an individual well or the amount of water available to the affected users. If the county determines the cause of the impact to be at least in part the responsibility of U.S. Gypsum due to the increased pumping, then the county will determine, and this will be through the use of third-party experts, whether that well that's affected can be rehabilitated by deepening it, or by replacing the pump, or in the case of water quality, by adding some wellhead treatment. Okay, next slide. And I just indicated the same thing happens if there are degradations to water quality. The county will work with their third-party consultant and with USG to determine if in fact the decrease in water quality, degradation of water quality, is at least in part caused by the increased pumping, and the county can determine what needs to be done to remedy the impacted well. All right, next slide. And the last mitigation measure is if the county determines that U.S. Gypsum has caused an impact to an individual well, either to water levels or to water quality, and that well cannot be rehabilitated, then the county can approve an alternative remedy, working with the affected well owner, which may require that U.S. Gypsum provide full financial compensation to the well owner for any costs associated with a residential or business relocation if they are unable to use their well any longer, as long as that compensation is consistent with applicable laws. All right, next slide, please. Okay, this is just a quick overview. CEQA 101, the California Environmental Quality Act, was enacted in 1970 to address concerns about environmental quality, and it establishes the procedures that lead agencies, being either local municipalities or state agencies, have to follow to do an environmental analysis and disclose to the public the environmental impacts. Next slide. The purpose of CEQA is to provide an information document so that the decision makers, meaning in this case Planning Commission or Board of Supervisors, with input from the public, can look at the potential significant environmental effects, identify ways to mitigate those potentially significant effects, and prevent any significant avoidable damage to the environment. So basically the preparation is of a disclosure document. Next slide. Okay, I think this is a little redundant. We can go to the next one. So in this case, we're preparing a supplemental EIR. As I said, the county certified an EIR, EIS, which is a joint document prepared with the Bureau of Land Management in 2008. Because not much has changed in terms of the project or the environment, this is simply a response to a court order. The county's determined a supplemental EIR to be the appropriate document. We're not looking at a new project, and we don't think that this qualifies for a categorical exemption from CEQA, but a supplemental EIR needs to be done so that the public has the opportunity to review these mitigation measures and to provide comments to the county before they adopt the new measures via adopting a supplemental EIR. Next slide. So the first thing I went over our development of a project description was the time we've spent over the last 12 months looking at all potential feasible mitigation measures and coming up with the 5 that I just reviewed. Tonight we're going to be conducting a public outreach scoping meeting in Ocotillo to gain further input from the public. Anyone who doesn't give any testimony tonight, there is still an open period to comment up until September the 5th. All of those comments, as well as any from additional county departmental staff, will be used to determine if there are any issues we haven't previously identified in the initial study that was circulated with a notice of preparation. Those would also be added if they're determined to be a part of the EIR analysis that needs to be done. So those will be included as new issues. The NOP has been circulated as of August 4th. It ends, as I said, on September 5th. We've given 31 days for public comment and for focusing the EIR. And that scoping meeting tonight, we will again introduce the project and take testimony, either verbal or written. Next slide. So the public has several points in time where they can provide input to the county to be looked at in the EIR evaluation. The first one will be the NOP 30-day review period, which includes a scoping meeting tonight. So there's 30 days for written responses on NOP, plus verbal testimony tonight. I understand you may be taking verbal comments today. Those will be recorded as well. Written comments can be submitted once the draft goes out on the street. We will, within the next 4 to 5 weeks after the NOP period ends, get the supplemental EIR ready for public review. That'll be circulated for a 50-day public review period, and people can submit comments on that draft EIR. And then there will be a hearing before the Planning Commission to consider the draft EIR and any comments received. And there will be a public hearing at that time. And if necessary, it will then go to the Board of Supervisors. Next slide. So what happens next and where we are, the next thing after tonight and through September 5th, we'll begin to compile all the comments received. Those will be documented in summary form. It won't include a full testimony. If tonight's comments were recorded, we would provide that testimony, but we will provide a summary of all the comments received. All of the written testimony will become a part of the EIR. It will be included. And any of those comments that are relevant to the supplemental EIR scope of work, which is limited to the revised mitigation measures, those will be responded to in the draft EIR. And then that draft EIR, as I said, will go out for public review. Next slide. For a 50-day period, and we expect that to begin in October of this year. And then the final document, including the responses to comments, will go to the Planning Commission and, if necessary, the Board of Supervisors for consideration of certifying the supplemental EIR. I think that's it.
Okay, that concludes staff's report.
Thank you. Does any of the committee members have any questions or comments for Patricia or Cheryl?
I got a quick question. It's kind of a specific question. The replacement of the wells as part of one of the mitigation measures.
Number 5.
Mitigation 5.
That's the
Yeah, it is, right, correct. Mitigation 5. Since the county requires conditional use permits for new wells, would that still be the purview of US Gypsum, the property owner, or how is that handled?
Yes, CUP.
Okay.
answer?
I have a question on this, you know, and in your presentation, you know, you stated that there's a monthly limit of 97 acres per month, right? Is a monthly limit?
That's correct.
That, and then what would happen if for any reason you had to exceed the 97? That would be, that's a limit per month, and you cannot exceed that?
If they do need to exceed that because of production demands, they would need to notify the county in advance and then start doing weekly collection of samples of both water quality and water levels.
But I thought it was if they exceeded 64, when they reached to the 64, then it started weekly, right?
Yes, I'm sorry, you're correct. So if it's exceeding 64 during any calendar month, then it will be weekly samples up to the limitation of
97.
96.
So 97 cannot be exceeded.
That's correct, 96, correct.
96.
That's correct.
Okay.
Sorry.
Are there any additional questions or comments for the Commissioner? Thank you. Is the applicant available? Please approach the podium. Have you had a chance to take a look at the initial study and the mitigation measures that are proposed?
I have reviewed those.
Do you agree with them? Thank you. Okay, at this point, I'm going to open up this item for the public hearing portion. And the main reason for this meeting is because it's indicated as a scoping meeting, is to provide early consultation to this supplemental EIR. And with that being said, we have names, and we will call the names. You come up and you give us some comments on the proposed mitigation measures.
Olivia Orozco.
That's the one I had.
Greg O'Donnell.
Please state your name and address for the record.
My name is Greg O'Donnell, 1589 Drew Road in El Centro. And I'm just wondering here, it says U.S. Gypsum expansion and modernization. I almost think that might be a misprint. It should be globalization. And I don't think that the acre feet that they're asking for is going to be enough water. If they have this high-speed system that they're putting in, they plan to sell gypsum overseas. Now, if you have a huge order and you need to produce it, and then the water levels go down, there's going to be some conflict there between losing maybe several $1 million on a contract to produce gypsum to get it overseas, or to fudge on the water. I think that down the road, that water table is going to go down to the point where the brine is going to come in and contaminate the water that exists. And I believe that a long-term solution would have been that IID should have provided water from the Colorado River for them. Because I think down the road, they're going to need it anyway. But then you've lost all the good water that's underneath the ground. And so that has me a little bit concerned, because if you have, in business, if things are on the line, you have to produce and get whatever you have out on the market, or you lose a lot of money. And I assume that U.S. Gypsum is a global company, is it? It is. Okay, thank you. I just kind of. But with that high speed, they're gonna use that, and I believe that that water amount is probably on the conservative side. But that the future remains that I think they should have a way out and have some other water source besides that. And I think that should have been put in place to begin with. In Ocotillo, you've got people who are disabled, you've got the elderly. You have people that lived there all their life. And can you imagine what it'd be like if one of you were to turn on your faucet and then wind up with water that's not very good, and they say you can't stay there anymore, or you have to get a new water supply, or they say that your place has now been condemned because it's not safe anymore for you to be drinking this water? That's something to think about. And because it happens to a neighbor, doesn't mean that it might not happen to you as well. Because life has a funny way of turning things around. And I just think I'd like for everybody to see things in the future. Out at Ocotillo, that whole place is very much like Palm Springs. But it hasn't been developed like Palm Springs, and I don't understand why. But I just, from what I see, I just really don't understand a whole lot. And so I have more and more questions that I'm trying to figure out and have answered. And how much, now the U.S. Gypsum is going to put in this water, and even though the water does go down, how is it going to be enforced? You're talking about a multi-million-dollar company, and who's going to enforce the measures to stop them from using excessive amounts of water? I don't really see too much strength in that area. I see it being monitored, and then people saying, yeah, you can't use anymore, it's too dangerous. But, when you have a piece of machinery moving like that, it's like a railroad. It's not going to slow. It can slow down a little bit, but not a whole lot. And I just wondering, because there were businesses out there that were selling water, and they were closed down because they were dropping the aquifer down. And I'm just wondering why this is different. It just seems like there might be a little double standard here that I don't really understand. And are they paying for this water? And then why are people paying for the water? And that I don't understand either, where there's another double standard there. And that's all I have to say. I just wanted to bring that up because I know down the road they're going to need a lot more water than what they claim right now. Thank you very much.
Thank you. Just point of information. We're here to take early comments on the supplemental EIR, so it's not going to be too much questioning and answering, going back and forth. We're here to take your comments and your questions, so we can make sure that when we start to address your concerns, we got everyone's concerns identified, documented, that can be included in the final EIR.
William Path.
Pate?
Pate.
Please state your name and address for the record.
William Pate, and the address is 25 West Imperial Highway, Ocotillo. My family and I have been in Ocotillo since I was 12 years old. I'm also an attorney. I also do public agency work and CEQA work. To me, this whole situation is on the fast track to 750 B Street in downtown, a couple blocks from my office. In case you don't know where 750 B Street is, it's where the 4th District Court of Appeal is located. These issues have been decided. The mitigation measures that have been proposed are not mitigation measures. The court was looking at alternative sources. And this is the time for this county to turn the page and to start doing the right thing for this generation and future generations. I've been down here since I was 12 years old. I'm now 47 years old. My 3 brothers have been down here. My mom and dad are retired Superior Court judges. I've represented the city of Murrieta for the last 12 years and watched it grow into what it is today. City of Chino, San Bernardino County, Los Angeles County. I'm working on the largest public works project in the history of downtown Los Angeles. help the homeless situation. And for years and for decades, I know a lot of people in this town, I've been coming down here and I've been wondering, when is Imperial County going to get it right? I have friends in Calexico, Holtville, who I went to college with. A gentleman who grew up in Calexico, went to USC Law, has worked for me for the last 10 years. When is Imperial County going to get it right? And guess what? There are no free rides in the 21st century. And United States Gypsum, that's 27% owned by Warren Buffett, that's publicly traded, has reaped the benefits of multiples of millions of dollars of free water since 1925. And this county should stop that practice. And you guys can do it. Turn the page. IID has a real opportunity to make money through the sale of water, which will not only increase local revenues, general obligation taxes, it will help your bond rating because you'll now have that huge facility tied to a public improvement. Be a lot easier for you guys to borrow money and do redevelopment, build schools, things that you really want to do around here and accomplish. Do the right thing. Nobody should be entitled to 4, 5, 600, 700 acre feet of water for free. Nobody. And you know what? All of this has been decided. A friend of our communities is Judge Harmon, Jim Harmon, former county counsel, who wrote a book back in the 1980s. His book discusses the findings that were made in 1973 by a hydrologist. In 1973, that a hydrologist employed by Imperial County determined that there's a fault that lies just to the east of Plaster City, which demarcates an area with very poor quality water. And pumping down the basin in Ocotillo, according to the hydrologist, will cause bad water to infiltrate the basin. We've known this for decades, and yet we continue to allow the manufacturing of wallboard for the 11 western states to get in the way of common sense. Do we want to be the generation that looks back and say that we contaminated the second largest natural water aquifer in the history of California? That it's gone. And by the way, that water aquifer is 82 square miles. It extends all the way into Mexico. And it was established during the Ice Age. And it is some of the best water. I'd invite all of you to my house. I have a beautiful well, beautiful property. And that water is so clean, so pure, it'll blow your mind. And we're walking on eggshells with it. I've done opening statements in front of juries where I've explained that, in my opinion, the two most important things that we do as a society is educate people and provide clean water. The rest of it we can live without. Trust me, the Indians did, the Native Americans did for 15,000 years. So where am I going with this? If you look at the alternate sources, that's what the court wants you to look at as a mitigation measure. There is only one alternate source, and that's the West Canal, 3 miles away. I also don't understand how U.S. Gypsum has been allowed to export water illegally. That question, trust me, this go around, I've been on the phone with attorneys who handled all these cases that started in 1998, and the county has lost every step of the way, and they will lose again. I see Justice O'Rourke, Haller, and Benke on a daily basis, and this will be the same result. These are not mitigation measures. These are arbitrary measures. Condemnation of my property is not a mitigation measure. What that is a pitfall that the county is going to have to deal with that's going to cost the county hundreds of millions of dollars. Just like all these monitoring efforts. 95% whatever that number is, it's some arbitrary threshold that all of us are going to have to sit around and debate. But at the end of the day, when the well goes bad, there's no fixing it. When a well goes dry, there's no fixing it. So let's get it right this time. They're exporting water 8 miles from one township to another. This lady said it on the record. It's in the record. Ocotillo and Plaster City are 2 different townships. There's a book that Jim has with it. We were reading it on the way here. It's called Ocotillo, A Place in the Sun, that was written by Miss Bernal. And it talks about the separate township of Plaster City with a picture of what it used to look like in 1925 when the cement factory went in. Well, guess what? That didn't give them carte blanche rights to extract as much water as they want out of an aquifer that isn't even underneath them. It's 8 miles away. It's just wrong. And when that water goes bad, it's going to fall on all of our shoulders. Because Ocotillo and Low Mirage and all those areas, they're not small communities. There's a lot of people that live down there, a lot of snowbirds, a lot of economic opportunity that this county ultimately needs to take advantage of. It's illegal to expand a non-conforming use. And the only thing that I can see is a 1-page letter from Planning Director Huberger way back when that classified their use of that aquifer as somehow a historic well. Someone needs to explain to me what that is, but at the end of the day, there's plenty of case law and plenty of statutory support under the government code that you cannot expand a non-conforming use. And you're allowing them to double the amount of water they're going to take out of that aquifer. And that just is not right. The mitigation measures are not mitigation measures. And let's get it right this time. Let's turn the page and watch this county boom economically. I've seen it in other regions.
Thank you.
Mark Ewing.
Good afternoon, my name is Mark Ewing, I'm an Ocotillo resident. Proud to be there, by the way. It's pretty hard to top all this information that you guys have just obtained.
Will you state your address as well?
Oh, excuse me, it's 98 North Imperial Highway,
Thank you.
right next to the wind turbines, which is another project that was put on top of us. I had to say it. Anyway, what we're talking about here is exactly what Bill talked about, regulatory capture. Big corporations, Warren Buffett, Berkshire Hathaway, coming into Imperial County, throwing their weight around for profit. It's not right. Let's go back to some of the numbers that you posted up here a little bit earlier. 64 acre feet per month.
Will you go to that slide there?
Is that right? 64 acre feet per month before testing would occur. Is that correct? Is that correct? Okay.
There you go.
I believe I'm right. So 64 acre feet per month before testing occurs. For example, say we took 63 acre feet per month before that testing occurs. That totals 756 acre feet per year. There's not that much difference between 756 and 767. Looks like fuzzy math to me. What's going to happen to the people out there in the time frame, and the third-party people that would determine that a well went bad? Those people just are they sent to a motel? Who waters their plants? Who waters their animals? This isn't right. Just exactly like Bill said, this is wrong. There's nothing wrong with getting water from the West Main. In fact, BLM and Regional Water Quality Control Board approved that way back in the 80s, I believe. And I believe there's a new enforcement with the Colorado River Basin Water Authority called SGMA. Are you guys aware of that? Anyway, that gives the right of Imperial County to control the water, manage the water. I believe by 2020, if overdraft had occurred, which is still 3 years away, then it would go back to the California board to enforce it. Well, that's too long. That's too long of a period of time. I'm all for modernization, but the expansion part of this is wrong. That's it for me.
Thank you. Next resident.
Jim Pelly.
Hello, my name is Jim Pelly. I live in Ocotillo, 1362 Shell Canyon Road. I'm a resident of Ocotillo and also the president of the Ocotillo Mutual Water Company, one of the 2 mutual water companies in Ocotillo. The draft supplemental EIR document for this issue has a serious error. There's no mention of the 2 water companies in Ocotillo. The mutual water companies are owned by the shareholders who are being served by the water company and deserve to know about serious issues of this nature that could potentially damage our only water source. I've received many calls from the shareholders on the water company. People are horrified to hear that U.S. Gypsum is pumping enormous amounts of water from our aquifer. They are all telling me the same thing. This is illegal. And I agree with them. Exporting water from a sole source aquifer is illegal and it needs to stop. What it all boils down to is it's all about money. A company that has a net income of around $510 million in 2016 that does not want to do the right thing and get their water for the needed for their drywall board from IID water source. Why? The answer is simple. Because they would have to pay for it. U.S. Gypsum has been pumping enormous amounts of water from our aquifer since 1925. They have pumped somewhere in the neighborhood of 30,000 acre-feet of water from our sole source aquifer and have not paid one dime for it. In San Diego, 1 acre-feet of water costs in the neighborhood of $1,000 to $2,000 or more per acre-foot of water. 30,000 acre-feet of water at $1,000 per acre-feet equates to about $30 million worth of water they got for free. And now they want to increase their pumping to 767 acre-feet per year, 7 times the amount of water that is consumed by the residents in 1 year. The aquifer is not getting recharged. It continues to go down. Here's a chart here from third-party U.S. Geological Survey from one of the residents, and it shows that their well has dropped 3 feet in the last 10 years. 3 feet in the last 10 years. It's not going up, it's going down. Basically, the aquifer is nothing but a big holding tank at this point. And when it's gone, it's gone. We certainly don't need a big company that is profiting off our water, reducing our water supply at a rate of 7 times the amount that we use for domestic use. I'm here to say enough is enough. Once again, the quiet little community of Ocotillo is being bullied by a big company, and Imperial County is siding with the big company that has one main objective: to make large amounts of money off the resources in Ocotillo. When is Imperial County going to do the right thing and start protecting the residents of Ocotillo? I'm sick and tired of getting these notices in the mail that says, this notice may affect your property. It should say, this notice could affect your property by 50% in value. The mitigation measures are a joke, as Bill mentioned. They all have this if inside them. So if they do damage our aquifer, it has to be decided whether they really did it or not. It should say when they damage our aquifer. None of these are acceptable anyway. Thank you very much.
Thank you.
Edie Harmon.
Edie Harmon, I live at 98 in Ocotillo. I live in the United States area. Mine is one of the wells that Todd Engineering can't seem to figure out whether total dissolved solids of 300 parts per million is potable or poor quality water. And I've addressed that in the comments. There's a lot of inconsistencies some technical information that make no sense. And the second letter that I submitted, 2 letters, one in the middle of the night that was 13 pages with 14 exhibits, and then another letter this morning with a 15th exhibit, so that you could see what Todd Engineering had submitted in 2007, where they've got information about groundwater basin, wells, historic impacts of pumping, and showing water level declines for a long period of time, by contrast to the information that Todd Engineering provided in the 2015 report that was part of the package for the notice of preparation. In the notice of preparation, they only want to show impacts to the wells in a short period of time. If you look at the USGS website, and you can see that in the table 10 that I submitted, and I've been continually updating that, and I have to say I've lived in the groundwater basin for 40 years. I've done work for the county council's office on several appellate court decisions to try to help the county win to stop the export of groundwater from wells in Ocotillo in Utah. So I've learned a lot, and I've learned that any member of the public and all these consultants can go to the USGS website. Within days of when USGS comes out and monitors the wells, and mine is a monitoring well, so I know when they're doing it and talking, they come out, they ask you to shut off the electricity at midnight so they can get static water level. When it's water level twice a year, or when they're doing water quality, they run the well for a long period of time to make sure they're not getting any contaminants that might be in the pipe, and they collect their samples. Within days for water level, the data is posted on their website. The water quality is posted on the website, and if you look for individual wells at the USGS website, there's an option to graph the change in water level for each individual well. So I don't understand when I look at the USGS website and I can graph, as you were seeing from one well, the data, and we get from USGS directly information that looks very different than some of what you're getting in technical reports that are prepared by both hydrology experts that show little impact. So I am concerned about some of the technical issues, and looking at what some of the technical experts say in one report and then in another. When it comes to the amount of water that US Gypsum proposes to export, I've raised the question since Jörg Huberger first signed the 2006 letter, March 2006, granting US Gypsum an entitlement to supposedly a historic usage of 767 acre feet. I have no idea why he would sign such a letter and make that claim when the appellate court in the year 2000, relying on information that was in documents supplied by Bookman Edmonston Engineering in 1996, they said that there was US Gypsum could provide no documentation based on either their electrical consumption or production that could substantiate the amount of water that they told US Geological Survey they were pumping. In fact, Bookman Edmonston told the county and the court that US Gypsum had inflated its water usage by 70%. So since that information was available, I don't understand, in 1996, I do not understand why in the year 2006 the planning director would ever make a determination of a purported historical use that could never be documented. I've submitted several Public Records Act requests asking for all documentation to support that determination. I have never gotten a response from the county. Why? Because I'm sure there is no documentation, or it wouldn't have been noted by the consultants for US Gypsum itself providing the data. So I think you've got some really serious problems, and when the county makes decisions based on information that can't be substantiated, I think that's part of the problem. And I agree, the mitigation measures make no sense. It was in April 2006 that Imperial Irrigation District approved a resolution with a grant of up to 1,000 acre feet to be able to supply up to 1,000 acre feet of water from IID, from the West Side Main Canal, for use only at the Plaster City factory site. And this follows a decision by BLM in, I think it was 1981, I don't remember the date, I got the paperwork somewhere, but I have to keep looking. BLM granted a right-of-way for a pipeline to provide water from the West Side Main Canal for industrial use in that area. The right-of-way was valid for 30 years, needing to be renewed. So when the county approved the final EIS-EIR in 2008, they knew that both an approval from IID for water use of up to 1,000 acre-feet of Colorado River water had been approved, and they knew that at that time there was still a valid right-of-way that had been issued by BLM. And the reason the right-of-way was issued was there was a challenge. There had been earlier a proposal to put in a cement plant adjacent to Plaster City. And that plant wanted to use 250 acre-feet of groundwater from the Ocotillo Basin, and it caused such an uproar that my understanding is it took an act of Congress to be willing to allow this use of water and the right-of-way to go out there so that there would not be industrial development depending on the small potable sole source aquifer. And it was in 1996 that US EPA made a designation of the Ocotillo Coyote Wells groundwater basin as a sole source aquifer, and you've got a colored map showing the boundaries of the US EPA sole source aquifer designation. US Gypsum vehemently opposed that designation, but US EPA made the correct decision because a sole source aquifer means that the overlying groundwater users depend for 50% or more for all their domestic use on the underlying groundwater basin. And in Ocotillo, the issue is we depend 100% on groundwater for overlying domestic purposes because there is no surface water. And I served on the Imperial, Regional Water Management Policy Planning, IRWMP. I was the only groundwater user on their advisory group. And one of the things that IID and people at IRWMP wanted to be sure that I and others understood was no matter what happens to people in the Ocotillo Coyote Wells groundwater basin, if that water is contaminated or depleted, it will never be possible to get Colorado River water supplied from IID to that area. We're uphill of elevation and there is no surplus water available. IID is still willing to make Colorado River water available for industrial purposes at Plaster City so that the residential communities that rely on groundwater for all domestic purposes will be able to continue living there. When the county earlier had approved mitigation measures that included providing bottled water, when you talk about doing laundry with bottled water or taking a shower with bottled water, people just think it's a joke. It's hard to imagine that the county, anyone in the county could have thought that that was a viable mitigation measure, or that any of the decision makers or people in the planning department would have wanted to live that way. I mean, I was a Peace Corps volunteer in Africa. We carried water from the swamp. But that was in the late 1960s, and that was the way people lived there because that was all that was available. Once you had access to water and you paid for a well, then you want to be able to use that water. And in Ocotillo, we can't carry water from somewhere else for all needs. So it's not really reasonable. And I remember times when I lived in Africa, I'd have to go 25 miles to a place where there was enough water to bathe because there wasn't enough where I was. And so I'm very sensitive to availability of water and the quality of that water. Anyway, and I have to thank Bill Page for his comments. I really appreciate what he had to say. I think that the most important, and I don't think in the packet there it included what I had written in the cover letter when I sent things electronically in the early hours of the morning. But going through the documents, going through the court decisions, I'm convinced that the only in the most reasonable mitigation measures are the two project alternatives that were identified in the 2006 draft EIR, either the full use or partial use alternative to get water from Imperial Irrigation District by a pipeline from the west side main canal. Those were dismissed, I think, primarily because US Gypsum did not want to pay to put in the infrastructure or treatment. But if you look at every community in Imperial County, I believe all the cities are relying on IID water. Each city has a water treatment facility to bring the water levels up to federal drinking water standards so that they can supply water for domestic use for people. If instead of challenging county decisions to do EIRs and to try to continue using water from Ocotillo and pay attorneys, if US Gypsum had been willing to invest the money when they first started talking about expansion and increasing operations in 1993, they could have made a lot of progress by now. Because ultimately that does seem the most viable operation. And in the past, I looked at US Gypsum annual reports, and I realized that they filed bankruptcy several times. And I remember at one point realizing they had built, I think it was 9 new $200 million factories while they were in bankruptcy. And you've got to feel really sorry for a Fortune 500 company who can afford to build brand new factories, but isn't willing to put the money into appropriate infrastructure in Imperial County to operate its facility here without jeopardizing the long-term viability and public health of the people in Ocotillo. It's really, in addition to a groundwater issue, it's also an environmental justice and public health issue. Environmental justice is something that California EPA and US EPA are taking very seriously. When I served on the IRWMP advisory group, one of the things I learned was that every community in Imperial County, with the exception of the city of Imperial, was considered a disadvantaged community because per capita income is low, and this is the poorest or one of the poorest counties in the state of California. So when you look, and I look at where I live, I've been there 40 years, I'm living on my husband's Social Security. I couldn't afford to leave and go somewhere else. If I were to have to move somewhere else, I don't have enough money to pay a monthly rent or to buy a house somewhere else. And I wonder how many people in Ocotillo could. And if when we're talking about money or buying people out, displacing people, in Ocotillo, people have private homes. They have homes, they have lots, and they have property. Where else could you go and afford the same kind or the same size housing, the same size lot for comparable money? I don't know any place in Southern California where you could relocate and start over if you had to. And most of the land that overlies the potable portion of the sole source aquifer is land that's owned by the Bureau of Land Management. But one of the documents I submitted to you was an exhibit that I think I prepared maybe like 2010, and it needs to be updated, but the potential population at build-out based on the zoning that was approved as part of the Ocotillo-Nomiraj Community Area Plan and estimated groundwater uses. Well, if you're going to allow export of potable groundwater for industrial purposes at the Plaster City factory, what does that say about the potential for people to feel secure, or even the wisdom of the county approving the drilling of additional wells on private parcels or approving construction of homes on the lots that are now vacant and undeveloped, but which are privately owned? And so I just don't know. I know originally when the Nomiraj subdivision was approved, it was intended that it would be supplied from a central water source, that there was going to be one big well. The problem was that in Nomiraj, the transmissivity and characteristics of the groundwater basin there were such that the well could not pump enough water to supply the homes that were there, so the county had to allow people to put wells on each individual parcel. The parcels are 2 acres there in size, but the groundwater basin has limits to what it can
Ms.
yield.
Harmon, can you wrap up your comments? You do have all of your comments.
I want to add one more thing, and that is, I have learned from well drillers and from experience that, yes, there's talk about drilling deeper, but I can tell you when our neighbor tried to drill deeper, he got salt water. And the county's consultant, David Huntley, told us if the export of groundwater wasn't stopped, we would have to move because we would be wiped out. And we would not be able to stay there. I was crying, but he said, if you weren't crying, I would think you didn't understand how serious it is, but you don't have the technical background to understand how much worse it is than you might think. So I think that some of these simplistic assumptions or proposed mitigation measures that are really more about monitoring and trusting that somebody's going to do monitoring right, they're not mitigation measures. And the fact that the county, I mean, how can you expect the public, after the board approved the statement of overriding considerations saying that U.S. Gypsum's interests were more important than the environmental issues or the well-being of the community, how can you expect the community to trust that the county is going to look after their interests when the planning director, based on no information, grants a purported entitlement of historic use to U.S. Gypsum, which U.S. Gypsum itself cannot justify? Anyway, I know I've got things in writing. I will get more to you, and please take it seriously, but I disagree that the appellate court decision says you only have to address 2 mitigation measures. And I talked with Larry Silver last night, and he encouraged me to be sure that I mentioned the fact that there needs to be an analysis of the full use or partial use alternative as possible mitigation measures to reduce the adverse impacts of the existing export of groundwater from the potable basin. And just because this Fortune 500 company doesn't want to pay, it doesn't mean that this Fortune 500 company cannot afford this issue.
Thank you. That was the last public comment. Is there anyone else in the public wishing to offer comments to the supplemental AR? Please approach the podium, state your name and address for the record.
My name's Roy Kaiser, 70 West Imperial Highway, Ocotillo. I just got one question. Is there somebody going to be at the meeting tonight that can answer these questions?
The reason for these meetings is to take your comments. We will eventually, throughout this process, answer or respond to all the questions and comments that you have.
But it's just looking from the outside,